I'm criminal defense attorney Aaron J. Boria, and we're heading in to the 35th District Court in Plymouth for a preliminary exam. So what's a preliminary exam? Anytime you're charged with a felony, the first time you go to court is for your arraignment. I posted about that on this channel before. That's where they set a bond and they schedule some court dates. Tell you what you've been charged with. The second time you go to court on a felony, it's going to be for what's called a probable cause conference. This is very similar to a pretrial in a misdemeanor case. And essentially at a probable cause conference, your attorney is going to talk with the prosecutor and see if there's anything that can be resolved this early in the case, if you're going to hold the exam or not, which is what we're doing today, or if there's any other issues that need to be decided, like evidence, discovery, things of that nature. In examination, a preliminary exam, the prosecutor has to put on a minimum amount of witnesses to prove that a crime was probably committed and that the defendant is the person that probably committed it. This is a probable cause standard. It's not as high as the beyond a reasonable doubt standard that we have in trial. A lot of judges feel that this is a very low standard. If that burden is proven, then the case is moved from the district court to the circuit court where a trial can occur. In most situations, the defense is going to decide whether or not they're going to hold the preliminary examination. Now, the prosecutor can demand it too, but it's less likely that they will. There are reasons why you would waive or skip the exam and head to the circuit court for trial, and there are reasons why you would hold the exam and make the prosecutor meet their burden. What are some reasons why you would waive an examination, not hold it, and just move on to the circuit court? In some situations, you'll find out that witnesses are going to testify in a certain way, or evidence will be presented that is going to result in your client having additional charges that they were not originally charged with. By waiving, sometimes you can avoid that from happening. Another reason to do it is there are situations where you think that ultimately you might get a deal on this case, and the prosecutor might tell you that if you hold the exam, there will be no deals. And that does happen, and it's totally allowed. Reasons why you might hold the exam, even if you don't think that you're going to win. You can lock witnesses into their statements, know what they're going to say when you go to trial, plan your questions around their answers. What happens if you win at exam, meaning the prosecution doesn't meet their burden? Depending on the charges and the elements of the crime, the case could either be dismissed or reduced significantly. I'm criminal defense attorney Aaron J. Boria. I hope you like this video. Feel free to call me at 734-453-7806 or shoot me an email at borialaw@gmail.com. Don't forget to hit that like and subscribe button.